In our criminal justice administration system, the accused were given more importance and the role of the victims were marginalized. They are just treated as the witnesses and evidence of the crime. Coming up with the definition of the victim, under Section 2WA of the CRPC fails to address the victims of abuse of power. Even the Malimath Committee and 154th Law Commission of India report also fails to address the victims of state action. But the UN declaration took a broader approach in this aspect and recognized the victims of abuse of power, which our criminal justice jurisprudence fails to address. Coming up with the 154th Law Commission report of India, it recommended for the victim oriented justice delivery system and payment of compensation out of the state's fund. Further, the Malimath Committee recommended for the participation of crime victims at the various stages of criminal justice. During the pre-trial process, the victim's first encounter is with the police. Class 4 of the UN Declaration recommends to treat victims of crime with compassion and respect, but still they are not sensitized to understand the pain and agony of the victim. In the case of offences against women, the police officer must record the information, failing which he will attract the punishment under Section 166A of the IPC. In the case of Lalita Kumari versus Government of UP, the Supreme Court held that the FIR is mandatory in all cognizable cases. Failing cases can directly reach the magistrate and can report his complaint. The major drawback of our criminal justice system is that the victims have no right to seek information until the charge sheet is filed. But the victim has the right to receive notice in the case of police has failed to report a closure report or magistrate decides not to take the cognizance of the offence under Section 169 of the CRPC. Another drawback of our criminal justice system is that the accused has the right to legal representation, but the role of the victim is limited to only prosecution witness. To overcome this drawback, after the Criminal Amendment Act 2013, Section 24 Class 8, Section 301 Class 2 and Section 302 was amended in CRPC. It provides a vital role to enter into the prosecution through a pleader appointed by the victim. In the case of JK Internationals versus State Government of NTC of Delhi, the Supreme Court held that the prosecutor is the only authorized person to conduct the prosecution, but at the same time, the pleader appointed by the victim is not debarred from the conduct of the prosecution. Coming up with the right to appeal, an amendment in Section 372 was added which ensures right to appeal by the crime victims against the order of the acquittal and secondly against the order for the conviction of lesser sentence and thirdly for the inadequate compensation. But still, the right to appeal for the enhancement of sentence was still in the hands of the state under Section 377 of the CRPC. Rather than punishing an offender, the payment of compensation would be a token relief to the victim of crime. Section 357 and Section 357A provides compensation to the victims of crime. Section 357 Class 1 Class B provides compensation through fine and Section 357 Class 3 of the code provides compensation even the fine does not form a part of the sentence. The order under this section will be failure if the offender does not have any financial assistance. Coming up with the victim compensation scheme, Section 357A provides compensation to the crime victims out of state fund. On analyzing the scheme prepared by the various states, it came to know that the amount fixed by them is very less with the nature of the offence. In Lakshmi versus Union of India, the court observed that the scheme prepared by the government is inadequate and ordered to pay 3 lakhs to the victims of acid attack and ordered to pay 1 lakh as an immediate medical assistance to the victims of crime. On the certificate of authorization from the police or magistrate or any other authority, Section 357 Class 6 of the code provides for immediate first aid and medical facilities free of cost. Section 357 Class C also directs any private or government hospital to provide first aid or medical treatment for free of cost for the offences covered under Section 326A, 376, 376A to 376E of the IPC. In the case of Lakshmi versus Union of India, the court directed to establish Criminal Injuries Compensation Board CICB under District Legal Service Authority. Coming up with the victims of abuse of power, the judiciary in the case of Rudul Shah versus State of Bihar directed the state government to award compensation for illegal embodiment of the victim for many years in the prison. By the way, the Supreme Court has recognized the compensation to the victims of abuse of power. In the case of Bhim Singh versus State of Jammu and Kashmir, the petitioner was illegally detained in the police custody. Fundamental rights under Article 21, 22, Class 2 was violated by the action of the state. In this case, the Supreme Court ordered the state government to provide compensation to the petitioner for the violation of his fundamental right. In the case of Neela Bhatti Behra versus State of Orissa, the Supreme Court ordered to pay compensation to the mother of the deceased where the deceased were killed by the police in the custody. Further, in the case of State of Punjab versus Abhijab Singh, the Supreme Court held the order of the High Court that even in the case of acquittal of the accused, the court ordered the respondent to deposit an amount of 5 lakh rupee to the dependents of the crime victim. Our findings are our criminal justice system lacks a victim oriented approach. And secondly, our criminal justice system does not recognize the victims of abuse of power. Thirdly, Section 2WA is very narrow compared to the definition of section under UN declaration. Fourthly, the victim has limited role in pre-trial process only as the eyewitness and reporter of the crime. And fifthly, the victim has no right to seek information during the investigation process. And sixthly, the right to appeal for the enhancement of sentence was still in the hands of the state. And seventhly, there is a lacuna in section 357 which provides compensation out of the fine. And eighthly, the victim compensation scheme prepared also does not provide adequate compensation to the victims of the crime. And ninthly, there is a need for separate legislation to address the issues of victims. These are the major drawbacks in our research in criminal justice administration system which we must address this issue in our criminal law. Thank you.